addition to that, you will find we now have what is known as the international covenants. The UN has come to be accepted as the representative of public morality, the international public opinion, and therefore UN conventions have a great role to play in national lawmaking these days. Gone are the days when each state, each country could legislate on its own. The legal power is there, but you are definitely influenced by international morality, international public opinion. And international opinion, the civilized world, the world is shrinking. They call it a global village these days, shrinking, so that no country can remain isolated in the thought, in the approaches. And that is why UN came out with certain a charter. I'll take you to that. You find several laws like that these days. Many of the Indian laws today owe their origin or their inspiration to international covenants, to which India is a party. You know the famous decision by Justice Krishna, where his lordship said that the interpretation of national laws can be influenced by international covenants, because they represent the civilized world's concerns. Similarly, you will find in 1989, the charter, the Convention on the Rights of the Child came out with a charter on child rights. I'm sure some of the speakers will be taking you through that. That is the international civilized society's concern for the child. You will find that expressed there. All the details will be taken through, but you have to know the charter on child rights. You will be giving them a copy of that. You gave me a copy of the charter on the child rights. You have to give them. I think you have to give them. When you go back, I want you to read them. Maybe nobody will be able to take you through the entire charter on Convention on the Rights of the Child. We may not be able to. Some of the classes will be taken, but you ought to have an idea at least of what the charter on the rights of the child is. International UN Declaration of Rights of the Child. Without that, you can't be good juvenile justice principal magistrate. You can't be. You have to read them. To put it in a nutshell, it expresses the civilized world's concern about the future of the child. Future belongs to the child. Civilized society's concern for the future of the child, it finds an expression in the charter of, in the convention, the Child Rights Charter. Please read that. You must give them a copy. Later it came, the Beijing Rules, as they call it, in 1985, which gave specific procedures or specific stipulations of how the Child Rights Convention must be interpreted. So the Beijing Rules, please give them a copy of the Beijing Rules also. You will also have the UN Rules of 1990, the preamble refers to all this. These three, in addition to the Constitution of India and the relevant articles, it refers to these. Please go through them also. As you know, if you are familiar with the international conventions and the charters, they are signed by member states, and most of them call upon the member states to enact laws consistent with the charter, consistent with the convention. That is how international public opinion gets reflected in a charter, in a convention, in an agreement, international agreement, and that transmits itself or permeates into national laws all over the world. Our journey towards a civilized world with a shrinking global village where we have fairly identical laws, you will find, will get expression by this process of international conventions calling upon the state parties to enact laws, and those laws in turn getting into the municipal laws of each country, and thus some uniformity in the internationally on the laws and norms of life which you have to follow. This sublime exercise you will find in respect to the child also, the convention, the charter, the Beijing Rules and the 1990 rules. When you go through, you will find the international civilized world's concern about the rights of the child everywhere. Child is too serious a business to be left to the nations, the community, or even the parents. Child's rights transcends all such boundaries. It is acceptance of this principle that you will find that is made in the preamble to the Act. Preamble speaks of all this. It may be necessary for you also to understand the national municipal laws background. As I told you, you must have been aware of the Kerala Children Act also, isn't it? Where also we dealt with the rights of the child. How a child, child, we call them the delinquent child, the neglected child, how they are to be dealt with, they are dealt with in the Kerala Children Act also. This state had a piece of law on that. All that gave way to the Juvenile Justice Act 1986. We had a national law on that aspect. Instead of the various state enactments, we had a national, the Parliament enacted the JJ Act 1986. Now came the 86 Act. In its implementation, we found there were so many inadequacies that the Parliament was supposed to come out with a new comprehensive legislation on the children. That is the Juvenile Justice Act 2000. That is the act with which we are going to concern ourselves with today. As I take you through the 2000 Act, I must caution you that the 2000 Act has undergone drastic changes in 2006. No understanding of the Act can now be made without being conscious of the 2006 Amendment. I will take you through the 2006 Amendment particularly because I think many of the problems that you will have to face today are covered by the 2006 Act. So that to such an extent that study of the previous provisions, study of the previous precedents have to a certain extent become irrelevant. I use the word irrelevant because so drastic has been the amendments under the 2006 Amendment to the 2000 Act. So actually many of us, I mean no disrespect, if you were to go through the decisions of the Supreme Court also, you find judges have not imbibed the fact of amendment or the spirit of amendment. Number of decisions have come later in which we find the subsequent decision of the Supreme Court acknowledges that these decisions have been rendered unmindful of the 2006 amendment. And therefore it's very important. I think the endeavor to have a session like this is very important today because we have to imbibe not only the 2000 Act but also the drastic changes that have been brought about by the 2006 amendment. Even the Supreme Court, I am not blaming the Supreme Court judges for that because those contentions are not taken, they were not argued. The changes that have been brought about by the 2006 Act were ignored. And you find a lot of conflicting decisions on the point. I therefore would not want you to go through all those decisions because of course those who are academically minded for the purpose of quenching your curiosity may go through them, but I would think that the Hari Narayan decision, give me the citation. Hari Ram was the state of Rajasthan. Scale citation. You can give the AR citation, give them the AR citation. To give them the Child Rights Convention, the Beijing rules, the UN rules, and this decision so far. I'll come to the other decisions later. You must read this decision. They will give you this. This is Hari Ram versus state of Rajasthan. Manupatra, it has been downloaded. We will give you a copy of that decision. This was rendered on 5/5/2009. I thought it was reported. It's not reported. Yes. It's there in the scale. Anyhow, you will get that decision, doesn't matter. It may be unnecessary to go through a lot of earlier decisions because the 2006 amendment and this decision rendered by that is the decision from which I quoted and read to you earlier. Altamas Kabir decision it is there in this. This is the decision that I am referring to. Their lordships have covered the entire gamut of the problem area and have come out with clear and crisp answers in this decision. They have acknowledged that some of the earlier decisions have omitted to take note of the 2006 Act and the change of principles therein. And therefore, I may not take you through all the previous decisions. It doesn't become necessary now. Academic interest most of them have become irrelevant now. And therefore, it may be enough if you go through this decision in detail with the provisions of the Act to which I shall draw your attention later. I told you, I'll give you the decision. The citation is Pariyano. Can you give the citation? Harirana. That's why scale you may not have, isn't it? Scale is very difficult. Except the height. I will see that you get a copy of that decision, and so no problem. Vanilla citation also you and that when you give it.
2009 6K 695. 2009 6K. Volume 6 page 695.
Scale SCALE.
SCALE capital letters.
It must come in any day. I thought it had come anyway. I'm sorry. Incidentally, I would also like to tell you, there is an article of a well-known author which is available in the Supreme Court cases journal section. An article by a person by name Veda Kumari, who has been doing a lot of pioneering work in the field of juvenile justice. I will please give them a copy of that also. Now that reading the Hariram decision and that article might perhaps give you a clear picture of the development of the law and the present law. Please go through that. I repeat, you must go through the Child Rights Convention, you must go through the Beijing rules, must go through the UN rules of the deprived child, the JJ Act 86, maybe not strictly necessary. Then you must see Hariram decision and that article by Ved Kumari. Things that I say now, if you are not able to clearly understand, I am sure once you read these decisions and these, you will be absolutely clear about that. Any inadequacy on my part in communicating my ideas to you will be made up by reading these 5 pieces of instruments which I have told you already. I shall later be looking critically at the statute also, but 2 things I would like to state right from the beginning. One, I have already told you that what is the method of law making in a democracy? How are laws made? How are laws born? Normally, our normal process of law making is society has certain needs. Society perceives certain needs. Like for example, in England, they found stealing a loaf of bread by a child would have ended in very capital punishment. Society felt it was unjust. Society felt that it needed a change. So in democracy, lawmaking always starts from the needs of a society. These must not only be needs, but they must be perceived needs, as Allen calls it in his law, the process of lawmaking. The needs must be there for the society. The needs must be perceived needs. When you perceive the needs, that is the starting point of the requirement of change in law. And the perceived needs must be accepted by the legislatures, which are the lawmaking bodies. And the need of the perceived needs accepted by the legislature gets expressed in the form of statutes. And when that statute is implemented, is enforced by the executive and interpreted by the courts, you get laws for the country. This is the process of lawmaking. The perceived needs, then public opinion accepting it, exerting pressure on the legislatures accepting it, enacting a law, executive trying to implement the law, courts interpreting the law, and that is how a change of law comes. But as I told you earlier, we are today having not perceived needs. Elite perceives the needs, not the needs of society. Classic example is the Sharda Act. Sharda Act is the act which says what do you call it now? The other act, minor children cannot be given in a Child Marriage Restraint Act. Child Marriage Restraint Act. Years back, visionaries in India perceived the need of a law which will prevent child marriage in this country. The law has been enforced for almost more than a century now, but even today child marriages take place. Why does that happen? Because there is a gap between the perceived needs. Community is not yet prepared to accept the change. And there is a big yawning gap between the perceived needs and the law. The law has run much faster than the perceived needs. And that is why even today in Rajasthan I am told there are certain days in which all kids of 3 years, 5 years get married. Laws unable to face it, laws unable to enforce it. And the reason is there is a gap between, a yawning gap, an unbridgeable gap between perceived needs and the law. See, the democratic lawmaking process has to a certain extent yielded to the needs of the civilized world. The world perceives, you may say world means the West. They perceive the need, have conventions, and we are called upon to enforce the conventions. And national laws are born not necessarily out of indigenous needs. It is the perceived needs of some others at some other different place, in some other totally different context, that you find they get transformed, they get imported into national lawmaking. So when we go through the Act, the particular provisions, I may be able to show you that there is a gap between the very elitist, refined thought of leaders of the community or the leaders of the world thought and the needs of our community. And hence you find, I am sure, many of you will, when I come to that point, ask me, why 18 years at all? Was not 16 years sufficient? No, you are going to ask me that question. It worries me also. Yes, you will ask. I am sure you will ask those questions. Why at all 16 years is not 18 years? Was not 16 years sufficient? And a 16-year-old boy, 16 to 18 is a good time to recruit terrorists. They indulge in all terrorist activities. They indulge in all nefarious activities. And am I to say, let him off with a warning? He commits the crime of murder. Many judges I have heard very conscientiously saying, my conscience does not permit me to do that, sir. Why? Because your thought process is not in resonating with the very refined thoughts in the Child Rights Convention. You are not able to accept it. You will have to know that this gap exists. That's the first point that I wanted to make you understand. This gap exists. And it is the ability of the interpreter, the adjudicator and the enforcer to make sure that not that the law is watered down, but the society is brought up to the requisite level. You have that mission before you. So you cannot say, oh, Indian society cannot accept 18 as the age of majority, age of crime, age of jolly income tax cannot cease there, and therefore it will not. No, that's not the way to look at it at all. This is where the mindset change concepts will have to come. You cannot be a diehard and say, according to me 16 was correct. Why did the legislature change it to 18? No. Legislative wisdom cannot be questioned by any interpreter. High Court and the Supreme Court sitting in the judicial review jurisdictions may sometimes set aside an act on the ground that it is ultra-wise, on the ground that it is not constitutional, even the ground that it is not reasonable. But down below, all the functionaries have to accept the legislature's wisdom in the statute. There is no room at all for your personal predilections. There is no room at all for your personal preferences. You as an individual, I as Mr. Basant may think that 16 should have been ideal. But when the law is amended and the law says 18, I have no room for that at all. I have to bow to the wisdom of the legislature and accept it, except where the High Court or the Supreme Court and judicial review sets it aside. That's a different story altogether. We need not worry about that now. So, international public opinion exerting pressure on national parliaments and national parliaments coming out with a law which may not be quite consistent with the norms, modes, accepted preferences of a community must be borne in mind by you when you try to interpret this law. Otherwise you will end up in a mess. You must always know that gap or not, I am bound by the law. I am bound by the law. I cannot question the law. When the law says, the problem is, as even the Supreme Court has fallen into that error, you are not mentally prepared to accept 16, raising of the age to 18, and then when a borderline case comes, you err in favor of your own personal thought. This is not justified at all. Supreme Court has repeatedly said, the law is very clear that the benefit of doubt on that aspect that is given to the accused. When it's 18 plus something, you are not able to fix, it's somewhere in the range that benefit will have to be. Even the Supreme Court in one decision said we are not able to accept. the concern of the legislative stipulations cannot be forgotten by any judge. Unless you set aside, you can always say raising it 18 was most unreasonable, perverse. On that ground, Maneka Gandhi's decision at Supreme Court or the High Court may caution. But in exercise of a different jurisdiction altogether. See, right at the moment that what I want to impress upon you is, let not your personal predilections, personal opinions in any way influence in the interpretation of the law. You may feel, justifiably as a citizen, you may feel that maybe it was better to retain it as 16. I remember the former social welfare director came here and once said, he quoted Ramayana and said, at the age of 16, a boy can be sent to the war. And that is our community, and then how do I accept this 18? That's a totally different thing. I would want you to close your mind on that. You are bound by the law. Your personal preferences have no place to play at all. Whether it came out of the perceived needs, whether the public opinion supported it or not, none of our concerns at the moment, because law declares that the changes will have to come about. Second one that I want to note is, the Act lays great emphasis on the societal participation in the protection of the rights of the child. It's not the state which alone is concerned. There's a lot of room given for civil society participation, be it in the rehabilitation, be it in the very constitution of a children home. For example, children home originally prerogative of the state. It could have been established only by the state. Now it says, if an NGO establishes a special home, children's home, etc., the state can accept that, and thereafter that will be a special home. There's a lot of participation for the civil society. The entire Act, as we take you through that, you will find participation by the civil society in this process is very important. How it gets translated to your actual performance. Now, supposing you want to send the child to a fit person or a fit institution, as I will later come, a child can be sent to a fit person, can be sent to a fit institution. You cannot think, oh, this is not established by the state, how do I send him to a fit institution? Law contemplates, law accepts that observation homes, all the homes can not only be set up by the government, but it can also be set up by private agencies if they have government approval. So two main things, that the international law is exerting pressure on the parliament to come out with an act like this, and second is civil society's participation. You have to ensure that civil society participation is made all the more relevant while interpreting this statute. Now I will broadly take you through the scheme of the Act. Now I've taken time for the preamble part of it and the motivations of the statute. The entire Act has only 70 sections, sections 1 to 70, and it is divided into 5 chapters. And the first chapter is, as you know, normally it's the definition, application, sections 1 to 3. They deal with the chapter is headed preliminary, and the chapter has 3 sections, 1, 2 and 3. We'll go into the details a little later. Now the second chapter deals with juvenile in conflict with the law. You know what a juvenile in conflict with the law is, isn't it? Immediately you think, oh, juvenile in conflict with the law, I know him. He is the delinquent child. We call him delinquent child. Oh, you have got chosen very wonderful names, but I know he's a delinquent child. See, it deals with the juvenile in conflict with the law. We will call him the JCL. JCL is juvenile in conflict with the law. The entire chapter 2 is a chapter on juvenile in conflict with the law. It deals specially with juvenile in conflict with the law. Impermissible though it be, I will translate into the language known to all of us. It is a child accused. It's a child accused, whom we used to call juvenile delinquent. That used to be the name formerly. I'm only introducing him to you. He is the juvenile in conflict with the law. The juvenile who is on the wrong side of law. He is in conflict with the law. And the definition says he is that who has, against whom there is an allegation of a crime. That is the juvenile. The entire chapter deals with the juvenile in conflict with law. They contain sections 4 to 28. You will have to go deeper into that particular chapter. I'll take you through that chapter. Now chapter 3 deals with a child in need of care and protection. That is a juvenile in need of care and protection. First one is JCL, juvenile in conflict with the law. Next is JCP, child in need of care and protection. CP, care and protection. Juvenile needing care and protection. And that you will say, oh, I know this man. Who is he? The neglected child. That was the expression when you were lawyers, you must have come across at least the Children Act, and at that time he was called the neglected child. So the entire chapter 3 deals with the child in need of care and protection, juvenile in need of care and protection. I will not take much time on that because I don't think it's very important for you, because that is a function to be performed by the child welfare committees. But you must broadly understand that. You will be taken through that later. But I may not take much time in taking you through that chapter on the child in need of care and protection. That chapter is primarily child welfare committees will be concerned with that. But any JJ board, any member of the JJ board wanting to discharge his functions must have an idea of the provisions relating to the child in need of care and protection. That is chapter 3, 29 to 39, sections 29 to 39, child in need of care and protection. Then we come to chapter 4, which deals with rehabilitation and integration. Again, I may not take you much through those. There's only for the 5 provisions, 6 provisions, sections 40 to 45, dealing with rehabilitation and integration. And chapter 5 deals with the miscellaneous provisions. They apply both to the child in conflict with the law as also the child in need of care and protection. I will have to take you through some of those provisions of chapter 5 also. Chapter 5, 46 to 70. They contain the provisions under the heading miscellaneous. Before I go to the next step, I will find there is a criticism against the Act, very serious criticism against the Act. It says the criticism is, a number of academics have come out with this criticism. They say it must have been 2 different chapters, 2 different enactments, and not merely 2 different chapters in the same enactment. The child in conflict with the law and the child in need of care and protection could not have been brought together under one statute in 2 different chapters. They really deserve 2 different enactments, and in having brought both these into one enactment, a lot of confusion has been created. I may agree, and on the broad academic side, I would think that it would have been perfectly better to have 2 different enactments to cover these 2 different, qualitatively different types of persons. But all the same, our legislature has thought it fit to come out in one act, and I think the academic pressure is so much on the government, not far away may not be the day when we may have different enactments. But it remains, at the moment it remains in one enactment. You must also be familiar with the model rules. Are any one of you familiar with the JJ Act does not give powers to the central government to make rules. It gives powers to the state governments to make rules. Yeah, only model rules. It gives powers only to the state government to make rules. So what happened was, even though this enactment came in 2000, no state government was implementing the law. It took a long time for the implementation of the law. The JJBs had to be constituted, the CWCs, the Child Welfare Committees had to be constituted, rules had to be formulated, notifications had to be issued, but nothing was being done. Central government was obliged under the convention to take action, and the central government started requesting the state governments to take immediate action. Kerala came out with the rules in 2003. We came out with the rules. 2000 the Act came in. 2000 to 2003 there was no structures available to implement the Act, and then you will find Kerala came out with the rules in 2003. Still JJBs were not constituted. You all